A person can renounce the right to receive an inheritance by executing a valid disclaimer. As we learn in DePaoli v. Commissioner of Internal Revenue, one common reason for doing so is to escape tax liability. When New Mexico resident Quinto DePaoli Sr. died, he was survived by his wife, Soila, and his son, Quinto Jr. Quinto Sr.'s will left his entire estate to Quinto Jr., who had two non-marital sons that he'd never formally recognized as his heirs. Soila and Quinto Jr. moved to have the will set aside, arguing that Quinto Sr. intended to leave Quinto Jr. $600,000, with the rest of the estate going to Soila. At the time, $600,000 was the maximum amount a beneficiary could inherit without triggering tax liability. To settle the estate, Quinto Jr. signed an agreement reflecting his father's purported wishes. The probate court treated the agreement as a valid disclaimer. Quinto Sr.'s federal estate tax return classified Soila's inheritance as a deductible bequest to a surviving spouse and indicated that no estate tax was due because Quinto Jr.'s $600,000 inheritance was within the estate's unified credit. The IRS denied Soila's marital deduction, reasoning that Quinto Jr.'s purported disclaimer was invalid for federal tax purposes because instead of merely disclaiming his interest in the estate, it also directed that the bulk of the estate go to Soila. The tax court agreed and deemed that the entire estate passed to Quinto Jr., who then gave all but $600,000 of it to Soila. The court also found that Quinto Jr. owed federal gift tax on the transfer to Soila and assessed a penalty for his failure to file a gift tax return. Soila and Quinto Jr. appealed to the 10th Circuit.